attempt number 4. The last one just did not save. This is like my last-ditch attempt to get this to work. In 2016, Ashton Barnes, I'm doing Barnes v. Felix for my project. In 2016, Ashton Barnes was shot and killed during a traffic stop in Harris County by Police Constable Felix. Barnes, who was driving a rental car, was stopped for unpaid tolls, and during the stop, Barnes began to drive off, at which point the constable jumped on the car and within 2 seconds of being on the vehicle, fired 2 rounds at Barnes. Barnes was able to stop and put the vehicle in park, but he would die of his wounds. His mom formed a legal team to, assert his constitutional right, or to defend his constitutional right under the Fourth Amendment, rather. In the district court where the case was first tried, the decision said that Barnes posed serious harm to Constable Felix, so he was justified in his use of force. On appeal, the Fifth Circuit Court affirmed the district court's decision, as under the moment of threat doctrine, Police Constable Felix did not violate Barnes's constitutional rights. So the moment of threat doctrine is a method of evaluating the reasonableness of an officer's actions, where you just look at the moment in which the officer was threatened, rather than the totality of circumstances. So the main argument that the petitioner is making, Barnes's legal team, is saying that the moment of threat doctrine is, quote, incompatible with precedent, conflicts with common law, and defies common sense, unquote. Say that the court needs to be able to look at the reasonability of an officer's actions and the totality of circumstances, right? So being able to see what led up to what's going on. Zelensky, who's the attorney making the oral argument, brings up Scalia's writing from Scott v. Harris, a case involving the ramming of a police car into a fleeing vehicle, where he says that the courts must slosh through the fact-bound morass of reasonableness. To be honest, I had to look up what morass means. Kind of a funny word. The defense, on the other hand, right, so Felix's legal team was saying that the court should not remand the issue or should not remand the case or issue judgment on the moment of threat doctrine, right, arguing that the circuit court really did look beyond the moment of threat, and the court really tears them apart for that. They're doing it, in my opinion, everything short of calling him an idiot for saying that. They really did not like any of his reasoning at all, and they comparatively, I felt like they were very nice to Zelensky. So when it comes to interpretation, there were a couple of examples to pull from. Precedent was definitely a big one, with how much they referred to other cases having to do with the moment of threat doctrine. I'm choosing to talk about textual interpretation for this, specifically how Justice Alito looks at the Fourth Amendment. To start, I want to read it to you. I'm not going to read the whole thing because I'm already running out of time. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Right, and then there's some more, but we really want to look at the unreasonable seizures part of the amendment. So during the decision, while the petitioner is first speaking, Alito says, quote, so unreasonable has a particular meaning when the court has to decide whether there was a Fourth Amendment violation. But in lay speech, unreasonable could go to whether the action was prudent, whether it was a violation of best police practices, or the practices of particular police department. Those are not necessarily the same thing. A little bit of alliteration there. That was hard. This shows how the written word of the Constitution, right, the unreasonable, has to be read as it was written rather than what unreasonable might mean to us today. And so that's sort of a bit of historical in there as well, but I really think that's an example of textual interpretation of the Constitution. So the verdict in the case was that it was remanded, right? So it was sent back down to the circuit court. Additionally, the court ruled that to effectively evaluate the reasonableness of an officer's actions, the court must be able to evaluate all the moments leading up to the climactic moment, and that does away with the moment of threat doctrine. Frankly, I'm not surprised. The justices were far nicer to the petitioner, Zelensky, than they were any of the other attorneys coming before the court, and to me it seems like they kind of had their mind made up beforehand. But I thought this was a really interesting way to get to learn about how the Supreme Court actually works. There are a lot of things that I learned from doing this project.